Fourth Department. Hear ye, hear ye, hear ye. All persons having business before this court will go out here, give their attendance, and they shall be heard.
Have a seat, everyone. Good morning. All right, and our first case for argument this morning will be case number 74, People versus Gladney.
Good morning and congratulations, Presiding Justice Bannister.
Somebody told you, huh?
I heard it through the grapevine. May it please the court. I'm Braden Gilman and I'm for Justin Gladney. For today's argument, I'd like to address point 2 of my brief unless there are other questions. Mr. Gladney was denied the effective assistance of counsel at critical stages of trial. Notably, defense counsel failed to object to the testimony of Dr. Ann Linane, which invaded the province of the jury. Dr. Linane's testimony was, despite the fact that she had never examined the complainant, she only reviewed a report created by an absent SANE examiner. That report, it had basically it was the testimony of the complainant at the top, and then the objective data categories were mainly left blank. Of 20 categories, I believe 18 were left blank. The only information filled in was that the complainant appeared withdrawn and nervous during the exam, and that the exam was quote unquote a benign exam. Despite that, Dr. Linane concluded that the victim had been sexually penetrated. And that went to a critical fact-finding thing that the jury could have done here. The jury needed to decide whether there was sexual intercourse in this case for the rape and the second charge here. And it was, this was not a particularly strong case put forth by the people. On the rape in the first degree charge, which was the sole allegation put forth by the complainant, was that there was a forcible sexual encounter here. The jury acquitted Mr. Gladney of that conduct. And when we also look at, for example, the forensic evidence here, the DNA evidence that was recovered on the complainant's shorts, there was a possibility acknowledged by both forensic experts that there could have been cross-contamination, and the complainant was Mr. Gladney was in a sexual relationship with the complainant's aunt, who lived in the home and whose clothes had been put in that communal laundry bin, as well as there was an unidentified DNA contributor to the mixture that was analyzed by the forensic experts here.
Counsel, so defense counsel had an opportunity to cross-examine the witness with regard to all those things that you talked about, correct?
That is correct.
And the complainant testified about what happened.
Yes,
Okay.
Your Honor.
So, so the facts that there was this expert witness, there was still an opportunity to be heard and cross-examined, and and fully explore that issue.
Yes, I believe that was the cross-examination was more so to ameliorate the harm that had been elicited when the expert here said that to a degree of medical certainty that it was consistent with sexual penetration.
Right. Do you want to speak to any of your other points?
No, unless there are any other questions, we will rest. Thank you.
Thank you.
Good morning. May it please the court, Will Zickel for the people. With respect to counsel's argument on the ineffective assistance issue, I would first submit to the court that Dr. Linane's testimony was almost as equally helpful to the defense as it was to the prosecution. Her conclusion was not definitive in the sense that she said, yes, this subject has had sexual intercourse. In fact, especially through cross-examination, she admitted that the way in which the victim presented, it was just as likely that she had or had not engage in sexual intercourse. And as counsel mentioned, the report itself was concluded that the exam was benign. So there was a very good tactical reason for defense counsel to allow both the report, which had the benign language in it, and the testimony of Dr. Linane, who concluded, hey, it's a toss-up here, to come before the jury, which allowed defense counsel to argue those very things on closing. So the defense has not established that there was a lack of a tactical basis for allowing both that report and that testimony. I certainly take issue with counsel's characterization of the people's proof in this case. I submit, as I indicated in my brief, that the proof in this case is very strong, including the testimony of the victim, the testimony of the other people living at that address, the finding of the communications between the defendant and the victim, and of course, the DNA evidence all add up to what I submit to the court as a very strong case. And finally, with respect to the totality of the representation in this case, I would point out that the defendant was acquitted of the highest count and was only convicted of the lesser count of rape in the third degree. If there are no questions, then I will submit
Thank you,
otherwise.
counsel.
Thank you.
Okay, case number 77 to 78. The matter of Ariel M. and Jazekia G.
Yes, Your Honor. Good morning.
Okay, I think we have some folks appearing virtually.
Mhm.
Okay, Mr. Greenberg, why don't you proceed?
Thank you, Your Honor. I'm representing the appellant in this matter. Our central theory, Your Honor, is that Ashley, the mother of all three children, completed her original contract for services, but faced hostility from the caseworker, in particular, Julie Minorchik, who was assigned to handle her case. I mean, the judge, in her opinion, which revoked the suspended judgment, said that her main concern was focused on her grievances with the department. But I think many of these grievances trace back to the day that Julie Minorchik became the supervisor for her case, because going into that, she actually had unsupervised visitation with all three children in her home. And then the children were there to prepare her to prepare the children to return to the home because she was at that point finishing her program.
Counsel.
Yes,
Ms.
Judge Ogden.
Didn't she miss several appointments? How can you attribute that to the caseworker if she didn't appear for the supervised visits like she was supposed to? And wasn't that one of the basis for the revocation of the suspended judgment?
Well, in response to that, there are actually 2 points I would make. Is that she missed some of these visits. Some of them for medical reasons. She presented documentation, but Ms. Minorchik stated that she had never seen it, but then later on she admitted that, well, she did see it, but she gave it to a different person. Then my client also had some transportation issues, and at one point she was also on bed rest because she had a subsequent pregnancy. And by the way, the child from that subsequent pregnancy is still with her. They never remanded the subsequent child at all. I mean, she still has a child in her home. So that would be the first point I would make in response to this business. And the second point is, why were they supervised to begin with? Because she originally, Your Honor, had unsupervised. And then there was an allegation that the children's father was in the home for a birthday party, and that wasn't true. And Julie, or Ms. Minorchik, used that as a pretext to bring in supervised visitation. Judge Novak.
Thank you for coming back. Now I have another question, but just on the last point you make.
Yes.
First of all, my first question deals with the judge below, her credibility determinations. Ms. Minorchik was the first witness called by the department.
Right.
And then of course your client testified as well. So in terms of this acrimonious relationship and who's at fault, it seems that the family court is in a little better position, in fact, a lot better position, because she saw the witnesses testify than we are. So that's question one.
Mhm.
But just following up on the last point that you made, it wasn't just the father of the younger two children being around. That wasn't the only problem with the visitation that led to supervision. Wasn't there a lot of testimony about things that were said to the children?
Yeah, but a lot of the things that were said to the children were actually said by other people, like the caseworker would bring in forms for her to sign. That was another problem that she was having with Julie. And getting back to that first point is the acrimonious relationship in family court. Who's best to make it? But a lot of it is in the record, because Ms. Menorchik in the record actually stated that she had a contentious relationship with Ashley. So I think that that's something that you can just look at. I mean, you can certainly, that I agree that as a matter of principle that the trial court should have, as being right there in the courtroom and to assess demeanor. I mean, there's so much case law on that point. I'm not, citing it all, would be here for like hours, but there's much case law. But
you talk about sort of what was brought to the visitation. From my review of the record, it looked like there was a lot of testimony that the mother was particularly focused on the foster parents and whether or not they were abusing the children.
That's correct.
That a lot of the visitation was sort of this cross-examination by the mother on the children as to whether or not they were being abused.
right.
And that was sort of like something that the mother couldn't let go of. In fact, even during one of the exchanges, accused the foster father of being a pedophile,
Right.
more than that, I think, a child molester, things of that nature.
Yeah, but some of that turned out to be true, though. I mean, she wasn't just on a fishing expedition. She actually had a fight to get the children out of the foster care with those foster parents, because they were not good parents to be with. And I think that also was also reflected in the record.
Where's the evidence in the record that was true? That the foster father was a child molester and all of that?
Okay, maybe
I'm not disputing whether it was true or not. I'm just asking where it is in the record.
Well, I don't think that specific fact about the child, about the foster father was ever proven, but it's clearly in the record that she did fight to get them out of that particular foster environment. That's one of the reasons why the children are currently in Louisiana, because I guess her plan for the children were to live with her mother down in Louisiana. I mean, my client has no family in Buffalo, or relatives are down to Louisiana, New Orleans, Louisiana. And so the plan was to get the children adopted by one of her relatives in Louisiana, but that fell through, and now they're in foster care in Louisiana. But the reason why they're in Louisiana to begin with is because she had to fight tooth and nail the department to get the children out of an abusive home. And I think maybe specific allegations like sexual abuse may not have been proven, but I think the overall allegation is the fact that they were taken from that environment. It does give credence to the idea that they were not in a good environment to begin with.
My sense of the record is it wasn't so much that they were taken out of the foster home because it was problematic. It was the fact that the move to Louisiana was so they could be with their grandmother,
That's correct.
who unfortunately has passed away.
That is
But
correct.
that's what prompted the move to Louisiana, as opposed to violence in the foster home up here.
Well, that's what prompted the move to Louisiana. But if the foster home up in Erie County was acceptable, why move them?
Well, perhaps to be with their grandmother.
Okay, Mr. Greenberg, anything else?
Oh, I could be here for quite a long time. I mean, quite a few notes. I mean, do you have any other questions that I could?
No, and I can assure you that we've all been through the record very carefully.
I want to just make one last point is it concerning the mental illness. I mean, none of the three children were ever formally diagnosed with a mental illness, and yet they put them on medicine for ADHD, even though I don't think a psychologist ever diagnosed them with that. So I think you should take that into consideration as well.
We shall. Thank you very much.
Thank you.
Good morning. May it please the court. My name is Tabitha Slonin, and I'm here on behalf of the Department of Social Services. So I just want to respond directly to what
That's what I was
counsel.
going to ask you to, if you could talk about the relationship between the caseworker and the mother.
I certainly can, Your Honor. So the record reflects that the caseworker in this case had an admittedly fraught relationship with the respondent in the matter. And that is not uncommon in cases such as these. This is hard. These are hard situations. We are dealing with families that have various different emotional, like it has various emotional effects on everybody involved in these cases, but that did not keep this caseworker from doing her job. The caseworker was very frank about everything in this case, and there were, I believe, multiple days of testimony in this case, and the other side had the opportunity to address these concerns.
And the court had an opportunity to view them.
Yes, Your
Listen to the
Honor.
testimony, view the witnesses as they came before her and make a decision.
Yes, that's correct, Your Honor. Over the course of many days, as the record reflects in this matter. I realize that opposing counsel wants us to focus on the fraught relationship, but the real issues here are the fact that the mother in this case did not follow through nor comply, for that matter, with the terms of the suspended judgment that she knowingly entered into. And this court has routinely established and upheld that the trial court can rightfully revoke the suspended judgment and terminate the appellant's parental rights as non-compliance with any of the terms of the suspended judgment.
The mother said that's all lies.
Right, and that's not an uncommon thing for a respondent mom to say in this case, but I think that the record establishes that within the ample amount of testimony that was set forth within this case over the course of a very long time, Your Honor.
And it was a long time, wasn't it? These children have been in foster care for many years.
Yes, that's an excellent point, Your Honor. Right now, we are holding up permanency for these children, and they have been enough. And I do not adore the characterization of counsel's argument regarding the mental health of the children in this case. Of course, the circumstances of their lives and this case in front of us today, Your Honor, is going to impact them. And I think that the record shows that the counseling that was engaged in for these kids was necessary.
But counsel, was it necessary to medicate them if there was no finding?
So, Your Honor, I do not purport to be a doctor by any means. But just because there isn't simply a diagnosis for, let's say, an ADHD on paper, a therapist can certainly look at the behaviors associated with within a child and see that they could benefit from medication, and that is for sure within their wheelhouse. And just because someone is on a ADHD sort of medication does not mean that it's being used for that particular use. I mean, in various instances when people are going through emotional things, it can be used as a benefit to help refocus and calm everything going on. But I think that point is irrelevant to this, Your Honor, respectfully, but I for sure can address that further if you would like. Thank you. So furthermore, I think that this case, coming back to the facts that were time and time again, very consistently represented within the testimony, I'd argue on both sides. The testimony supported that the court ordered the report by Dr. Nathanson, and then the mom didn't follow through with the recommendations as provided. The appellant failed to attend all but 2, I believe, of the counseling appointments for her child, failed to attend all of the medical appointments for her children and had ample opportunity to do so, failed to consistently visit her children without reasonable documented excuses. And I know that it is counsel's contention that there were reasonably provided medical excuses, but I think that the record respectfully disagrees with that notion.
And so did the family court judge.
Yes, that is correct, Your Honor.
Okay, thank you, counsel.
If there are no further questions, I will rest on my papers. Thank you.
Okay, who's up next? Miss Herod?
Good morning, Your Honors, and may it please the court. Roxana Herod of the Legal Aid Bureau of Buffalo on behalf of the child Ariel. Our position is that the decision of the trial court to revoke the suspended judgment terminating the parental rights of appellant was clearly supported by the evidence put forth at trial. At fact-finding, the department established by a preponderance of the evidence that appellant failed to comply with several of the terms of her suspended judgment, including failing to comply with treatment recommendations made by Dr. Nathanson, failing to provide proof of verified income or adequate housing to the department, failing to attend and engage with the children's counseling and medical appointments, and missing multiple visits with the children without providing appropriate documentation.
How is Ariel doing in Louisiana? Or
My client Ariel is currently placed in a pre-adoptive home with her siblings where she feels comfortable and supported. She's bonded with the foster parent. She's attending school, engaging in age-appropriate activities, and is enrolled in counseling. She's very happy down there, Your Honor.
And how long has she been with these pre-adoptive parents?
Your Honor, I believe she has been with this pre-adoptive placement for a little under a year. I think she was moved to the home after her grandmother passed.
okay, thank you, counsel. All right, Ms. Connell?
Yes, thank you. May it please the court, I have the honor of representing the two younger children in this matter. They are similarly situated. They are with a loving pre-adoptive foster parent. They are happy to be with their sister. They are engaged in music and doing well in school. The younger boy does still struggle, but the foster parent has brought him a long, long way. So they are doing well, and I would ask the court to uphold the decision of the trial court. I want to address a few points that were made by Mr. Greenberg. One is that his client fought to get the children, and in this case, it concerns my two younger clients out of an abusive foster home. There is zero proof that that was any of those adoptive homes or pre-adoptive homes were abusive. These were all made up by the mother, and the parents, foster parents, simply gave up because of the relationships that was being destroyed by the mother. There's no proof that they were abusive, no CPS findings. And so I take umbrage that any of these foster parents' good names are being smeared. With regard to the fraught relationship with the caseworker, Ms. Minorzik, first of all, as was pointed out, it's not unusual. Second, she was not the only caseworker involved. She was one of at least 3 or 4 caseworkers. And if we're going to talk about fraught relationships, the record is clear. Ms. Carter went through 4 attorneys during the course of these proceedings, including attempting to fire the attorney who was doing the hearing during the course of the hearing. So I think that should lay that issue to rest. And again, with regard to credibility,
The court was in the right place at the right time to be able to observe what was going on.
absolutely. And the mother admitted many of the violations of the suspended judgment. So I would ask the court to uphold the findings of the trial court. Thank you.
Thank you all. Okay, case number 79, matter of Brody versus Brooke Kalaf.
Morning, Your Honors, and that was my phone that rang. I apologize.
Not a problem.
It's now outside.
Okay, hold on one second. Okay. I think we have one more video. There we go. Okay, Mr. Bell.
Good morning, Your Honor. May it please the court.
Before I get into my oral argument, something has occurred that I believe we need to report to the court, which is on December 28th of 2024. There was an incident at the father's home in Fredonia, and he was voluntarily, according to him, but the police took him for a mental health exam. On January 1st, I believe, Judge Carter issued an order basically transferring placement of this child to the mother. We appeared in the Chautauqua County Family Court on the 6th of June. Judge Sullivan, who was the trial judge here, has scheduled the matter for another hearing on January 23rd. And on January 8th of 2025, here just now, there was an extreme risk protection order issued against the father. He needed to surrender his weapons. Now, this all occurred after we filed our briefs. I don't know how much the court wants to know about that, but I believe I'm required to at least inform the court of that proceeding. Ms. Evans, the AFC, was involved, at least she was present virtually, I believe. And the trial attorney, Ms. Jarzynski, was also present in the family court. She'll be representing the father when we go back on January 23rd.
Okay, so there's other proceedings there that could affect this appeal and what comes out of here.
Exactly. And again, at present, the child is placed with the mother. There is an order of protection in place because of what happened at the father's house.
Where's, excuse me, where's the child going to school
The
now?
child has been going to school under the order in Fredonia. With the change that occurred a week ago, the child is still going to school in Fredonia. So there's been no change of schooling for the child. She's now in 3rd grade, I believe.
So the mother's driving the child that hour back and forth every day.
The mother or her husband, but yes. And that had been occurring throughout the earlier proceeding that the mother was seeking to have the child go to school in Cattaraugus Little Valley, which is in Cattaraugus County. The father is in Fredonia, which is Chautauqua County. Mother was taking the child to school on her 2 days each
I think
week
we realize that, but now she's actually living full time with the mother.
for the last week since the child went back to school after the Christmas and New Year's break. I'd just like to focus on a couple of things. The court has said correctly, of course, multiple times during my brief sitting here that we always delegate to the trier of fact, the judge who heard the testimony, weighing credibility. The issue that was in front of the family court judge is, should the child be permitted to go to school at the father's home or from the father's home in Fredonia or from the mother's home in Cattaraugus Little Valley? The child had gone to kindergarten from the mother's home, 1st grade from the father's home. The judge was called upon to say which school. The judge listened to all the witnesses and made a determination. I don't agree with the determination, but that certainly isn't something that the court is going to overrule. But what the judge did is 2 things, I think, which is incorrect. One of which is that he made a determination that wasn't asked for by anybody. There was a pleading by the mother saying, I'd like the child to go to school in my district. The father said no, but he didn't say he wanted to change the existing custodial arrangements. This was by agreement, a 5-2 split. So the parties had an equal sharing. During mom's days, she took the child to school in Fredonia. During dad's days, of course, he took the child to Fredonia. The father was not asking to change the 5-2 equal sharing to what ended up being a 26-4 sharing, with the father having 26 days a month and the mother having 4. Not only didn't he ask for that in any pleading, but I specifically cross-examined him on that issue, and he didn't believe that the 26-4 or the alternate weekends only to mom would be in the child's best interest. At the end of the case, all 3 attorneys were given an opportunity to submit our summaries. That's part of the record on appeal. Even the AFC, who had been with this child for quite a period of time, there was some earlier litigation in the divorce, even the AFC recommended that, although she said, I think the child should go to school in Fredonia, there should be no change in the equal sharing. There was no evidence at all that the fact that the child had to be driven from mom's house to school or the meeting place, they were meeting at a restaurant, was having any detrimental effect on this child.
The other issue that I believe the trial court had no jurisdiction to do is on the third day of the trial, this would have been September 7th, the father files a petition saying that the older boy, Landon, is in the house and this isn't proper. I think the child's at risk. Judge Sullivan took an extreme amount of time to announce and stipulate on the record, I am not dismissing that petition that was just filed today, but I'm not hearing any testimony regarding it. He said specifically on the record, we will schedule this for arraignment. That was on September 7th of 2023. My client still hasn't been arraigned on that petition. So after saying that I'm not going to even consider any of this, he puts into his decision that part of the reason I'm ruling in favor of the father is the mother didn't tell the father that the older boy was moving back in, and he imposed these restrictions of locks on the door. He had no basis to do that. And he made it very, very clear on the record that he was not going to do that.
Locks or was it a lock?
I'm sorry?
It was alarms. It wasn't locks, right?
Alarms.
It was alarm, right?
It was an alarm, and what the judge decided is that I'm directing you, mother, to put door alarm locks on Alexandria, the daughters.
On both doors.
Yes.
Okay.
Right. And in addition to, again, changing the basic structure from 50-50 to 26 to dad, 4 to mom, he, during the summer, the judge did this, said, I'm going back to the equal sharing. So for then, the summer of 23 and the summer of 24, the child has been, the daughter has been with the mother for half the time.
Just with respect to that argument that, you know, that this was relief never asked for, it looked to me that in the mother's original modification petition, which she was citing was the burden of the travel on the child. So the mother was sort of putting this issue out there that, and again, her goal was different. Her goal was, I think the child should be with me in Cattaraugus.
Yes.
But there was a problem with the child going back and forth, a 5-2 arrangement. At least it seems that was presented to the court. The court had to make a decision, ended up going the other way. But didn't the mother put that out there?
The mother asked for primary placement. She absolutely did. And she said that I'm having difficulty with the Fredonia school officials. They're not giving me information. And when the child was in Cattaraugus Little Valley, naturally it was closer for the mother, that it was easier for the mother as she felt that the Cattaraugus Little Valley people were more cooperative. So she indeed was asking for primary placement. I specifically asked the father that, and I've identified that in the record on appeal. I specifically asked the father, is this something, primary placement with the mother, do you think is in the daughter's best interest? And he said no. And I said, do you think it would be in your best interest or even the child's best interest to have primary placement with you and what ended up being the 26-4? And he said no. So again, if the mother isn't asking for this big change where father gets 26 out of 30 days, if the father isn't asking for it, and if the AFC isn't asking for it, where would then credibility come in for the judge? Where would he get that?
Well, admittedly, that was before his father found out that Landon was back in the house.
All right, but that was never before the court. Again,
Understood.
I'm sorry, I've said that.
But the custody issues, wouldn't they necessarily, there be an examination of each of the households, and isn't Landon's present in one of the households, a relevant issue for the court to discuss and consider?
If it was in front of the court. And again, my client never had an opportunity to respond to these allegations. What the father's concern was, I don't know how much deeply you want me to get into this, is that when the child was an infant, the child was 7 at the time.
We read that in the record.
Right.
We know that incident occurred.
But my client never had an opportunity to respond to those allegations. I'd point out for the court, and Judge Sullivan made this clear, is that the divorce judgment, that was the guiding document. The divorce judgment simply said that Landon and Alexandria were not to be left alone without an adult present. There was no allegation in the brief testimony of the father that ever happened. He was concerned, but there was no suggestion that I know that Landon and Alexandria are being left alone.
No, but he certainly knew that it could happen since they're now residing in the same household and there weren't safeguards.
Of course that could, but again, how can my client be held responsible if she's not given an opportunity to respond to the petition?
And I guess from reading the record, the mom didn't tell dad about Landon's presence in the house until the third day of the trial, according to the record.
The AFC interviewed the child at that house with Landon present, but did my client say to the father that Landon had moved in on such and such a date? No.
So that may have cut off her ability to explain it if she didn't first give notice.
And yes, that may have, but again, it wasn't before the court, Judge, properly.
Counsel, one concern I had, maybe this, again, it's the same answer that you gave, that it wasn't before the court or wasn't before the court yet. But in response to, this allegation about Len being present in the house, I expected when reviewing the record that the mother was going to present evidence that Landon's not a harm, not a concern, not a danger to the younger child. But I didn't hear that. I heard instead, oh, we have precautions in place. My husband's up all night because of his medical illness. Or, I heard other things that seemed to almost acknowledge that, yeah, we recognize this is a real danger. And that surprised me a little bit. But is the reason because there just wasn't time to put that proof in? Or
Right. Yes, Your Honor. It wasn't before the court. You're absolutely correct in your recollection of the record on appeal. But the judge made it clear. He specifically said, I'm not going to dismiss the father's petition that was filed on the third day of trial. I'm going to schedule this for an arraignment. I assumed what would happen is between our last hearing date of September 7th and whenever he made his decision, we'd be called in. My client would be given an opportunity to respond both in writing and with testimony regarding Landon. We never got that opportunity. Again, she still hasn't been arraigned on that petition. The reason the petition isn't in the record on appeal is because of exactly that.
just my last question is your position now that in light of the recent events that this appeal is academic?
I wouldn't quite go that far because I don't know what Judge Sullivan is going to do in light of
It could
this.
become academic, but it's not.
I'm sorry.
So your position would be it could become academic.
Yes.
It's just not at this point.
Right, because I have no idea what Judge Sullivan is going to do. I will say to the extent that he's determined after 3 days of trial that the father's home is more appropriate. I don't know that he's going to do anything. I do know that there's this extreme risk protection order from a week ago against the father.
Okay. Anything further?
Any other questions?
Thank you.
Thank you for the time.
No problem. Counsel?
Thank you, Your Honors. With regard to the issue with Landon, I think that the court naturally will, under the facts versus facts factors, consider both households and what is the situation in both households. We all know that when we go into a modification trial, that the court is going to consider what is going on in each household to make a determination. In addition, the mother did conceal Landon's full-time residence in the house. And so because of that, it did not come out until the trial had already started. But I don't think the court can, in good conscience, ignore something like that when that was definitely a provision in the divorce decree. And the court certainly, needs to be looking at that sort of factor in determining which household is best for the primary placement.
And that factor is something that everybody was concerned about even before this, the school issue came up. It was something that was provided for in the judgment of divorce.
Exactly. Yes, Your Honors. So I think there was definitely a sound and substantial basis in the record for what Judge Sullivan did provide in this case. There was also plenty of opportunity in the trial for the mother to explain, why she had not been more forthright about Landon's presence, or, I was hoping that there would be evidence that she certainly could have talked about any help she tried to get Landon, but none of that was ever discussed in the case. So,
But was the other petition pending when the trial was going on?
the first,
Involving Landon, was that a pending matter?
no, because no one knew that he was in the household until the third day of trial. And then immediately after that, I was not trial counsel, but I understand that immediately after it was revealed that Landon was in the house, then a new petition was filed within days of that. And that was revealed during the trial, and a new petition was filed. And my position is that even if the court it was correct in saying, okay, I'm not going to hear that particular petition, it can still hear all the information about whether Landon creates a risk to this child as part of the facts versus facts criteria in determining, which household should be the best placement for the child. And so no matter what, the court could consider that information.
Counsel, can I ask you to comment on, the more recent events that Mr. Vella has brought to our attention, and how we should consider all of those with regards to resolving this case?
Sure. I am not trial counsel, so I don't have access to the information. I was advised by the attorney who is handling that matter in Chautauqua County, Sally Jarzynski, that there was a court appearance, I think last week, that there is a full stay away order protection existing between the father and the child, Allie. My understanding is that there were no allegations of any of Ellie being involved in the incident. My understanding is there was a mental health crisis in the home, that it happened at a time when Ellie was asleep. But I don't know anything further than that. But I think as an abundance of caution, the court did the order protection. I do understand that that there may be a carve out so that he can have access with the child.
And that's for family court to discuss. I guess I wanted you to comment with regard to procedurally, what you were expecting of this court to do with this appeal, with those issues still outstanding. And I guess at very least, I would ask that counsel keep in touch with the court and let us know what those proceedings are in the future, okay?
I will, Your Honor, yes.
Okay.
Other than that, I'm happy to rest on my papers.
Thank you, counsel. Counsel?
Good morning. May it please the court, Lydia Evans, appearing for the child, Allie. I have, as already referenced, represented Allie in several proceedings, including the divorce proceedings. So we have met on multiple occasions. And most recently, I met with her last week on January 8th at her school. She continues to do relatively well. As so many of my young clients do, she is remarkably resilient. I just want to address the recent events that we've been talking about. I met with her for about an hour, and we discussed the situation, kind of the posture of things to the extent that she can understand that. And I can confirm that Allie was asleep. She is aware that there was an incident at the house, at her father's house.
We're going to let family court deal with that incident. I guess I'd like you to just comment about how you think it affects what we do here with this appeal.
Sure. I have no difficulty with this court, Your Honors, delaying a decision until we have this trial on January 23rd, and Mr. Vella or I could contact the court to let you know exactly what happens at that proceeding. Hopefully we can wrap it up that day. But back to Allie, she's 8 years old. She's in the 3rd grade. She is still attending Fredonia schools. She's been there since the 1st grade. Her mother is driving her back and forth. She's a good student, has lots of friends. Relative to the instant matter, based on my meeting with her, and we went over this carefully, I am not at this point advocating any change in my position. I asked the court to affirm the lower court's decision. I'm going to be meeting with her again. I can certainly advise the court if our position changes, but at this point, I'm not changing what I have advanced in my papers, and I'll rely.
Thank you, counsel. Okay, number 80 and 81, matter of Aiden. Donald, I think you're the only attorney that's checked in to argue.
Oh, all right.
Hold on a second. Yeah, two subs. I have it here in red, maybe they wanted to. Sorry about that. You have the floor.
Oh, all right, thank you. Well, I can advise the court that my client is definitely a teenage boy who enjoys sports. His academics have improved immensely. He is in a loving pre-adoptive home. He definitely wants to be there. And I would ask that you affirm the court below. The adjournment request was properly denied. It's in the discretion of the judge. This is a case that's gone on for many years, and the mother did not have a good excuse for failing to appear. It's not up to her attorney to remind her, even though he did. But he did remind her. She simply failed to appear. She did not call the court. She did not call her attorney. She did not advance anything the day of the hearing to advise the court as to why they couldn't. The court, having gone forward, did give her attorney an opportunity to present a written motion. He did, but there was no reasonable excuse for her failure to appear. And
all right, so you think that the default was justified?
Absolutely, absolutely. She did not have any contact with my client during the relevant time period, and I would ask that you affirm the court below.
Thank you, counsel.
Thank you.
Okay, case number 82 and 87, Werfel versus Courtroom and Werfel versus Shahid. Ms. Hager, good morning. We can't hear you. Unmute yourself.
Good morning, Your Honors.
There you go. There you go. Okay. I guess this is your argument.
May it please the court, Tamsin Hager on behalf of the Dr. Shahid defendants. Our position on this appeal is that the plaintiff failed to raise a tribal issue of fact as to deviation from the standard of care and as to proximate cause, and that Dr. Shahid's summary judgment motion should have been granted in its entirety. Taking the first matter first, standard of care, Dr. Shahid opines that the findings of his abdominal exam on September 11th at noon, which was his sole encounter with the patient before this patient was diagnosed with a perforated colon 5 days later, showed no signs or symptoms of immediately concerning constipation or severe constipation.
Did he check the nurse's notes?
He did say in his affidavit, David, that he did not check the nurse's notes and that did not deviate from the standard of care. And the important fact here is that
wouldn't that be an issue of fact of whether or not checking those notes ahead of time, which clearly indicate that there was a problem?
The notes ahead of time, the nurses that saw the patient ahead of time did not note any distension. The abdomen was soft. It was non-tender. There were bowel sounds in all 4 quadrants, which is a similar finding that Dr. Shahid had when he saw the patient at noon that day. So the preceding nurse's notes are consistent with Dr. Shahid's abdominal findings as well. And the importance of those abdominal findings is they don't point to any immediately concerning constipation problems or severe constipation.
But didn't they say he didn't have a bowel movement at all?
That there was inconsistencies in the chart about when the last bowel movement was. And again, I'm going to point to the abdominal exam findings at September 11th at noon, which showed a soft, non-tender exam. And there was no pain, there was no tenderness. And in addition, a constipation regimen had just been recently begun. The patient had just received a dose of Colace, and that morning, a second dose of Colace and a dose of Miralax. So Dr. Shahid's opinion is that given the abdominal exam findings on September 11th at noon, and given the early beginnings of a constipation, a laxative regimen to address constipation, he was within the standard of care in awaiting and continuing that regimen and awaiting the effects of that regimen. And
was it his responsibility at all to, considering all the different dates of the last bowel movement, to try to figure that out?
I think that what you get is the clinical presentation when he does the abdominal exam, and the same with the nurses ahead of him, that we're not having a situation where we're concerned with severe constipation. We have a regimen on board that's addressing the constipation. And so in contrast to this, the plaintiff, in trying to raise a tribal issue of fact, does not even address the findings of Dr. Shahid's abdominal exam, and doesn't address it in the factual history, doesn't address it in the opinions, and so cannot raise a tribal issue of fact regarding that issue. They also.
Counsel, why shouldn't we be looking at this, though, in terms of what the standard of care is? You have Dr. Shahid saying that all you got to do is do this exam. And if I make these findings on the exam, it doesn't matter what the nurses say, and it doesn't matter about when the last bowel movement is. And then you have the plaintiff's expert that says, no, even with the exam, you still need to find out about the last bowel movement. You need to check the nurse's notes with respect to that. That's the standard of care. So it seems that we have just this credibility battle as to what the standard of care is, and why shouldn't that go to the jury?
Well, I would point out that the plaintiff's expert doesn't actually address any of the facts of the exam, while Dr. Shahid does. And that the exam, Dr. Shahid's opinion is that in light of what the exam showed, and again, there's not distension, there's not pain, there's no sign of severe constipation at this point. So under that scenario, you can continue the regimen for constipation and await as it's.
And that's what he says, but there, as was just pointed out, there's a conflicting opinion out there. So isn't that an issue of fact?
Well, I think we met our burden in showing that there was no deviation from the standard of care. And then the plaintiff's expert did not raise a triable issue of fact regarding what we met our burden on. So, and they're lacking reference to the facts of the actual case, what Dr. Shahid's abdominal exam actually showed, and not addressing critical aspects of what the case was at September 11th at noon. The plaintiffs cannot raise a tribal issue of fact.
We'll look at the experts' opinions very carefully. Okay.
Any other questions?
No.
Okay, thank you. Thank you.
Good morning, Your Honors. If it please the court, John Collins on behalf of the plaintiff. The trial court properly found that this is a case with a classic battle of the experts.
So, Mr. Collins, why don't you address, where in your experts' affidavits or otherwise, those things were addressed, the standards of care and the questions of fact that you claim there are.
Yes, the expert, our expert stated that position in Dr. Shahid's position, examining a patient such as Mr. Werfel 2 days following, 2 surgeries, had an obligation to inquire when he had a last bowel movement. He also had an obligation to reconcile the very disparate nurse's notes stating when there had last been a bowel movement.
And
those range.
How would they have made a difference? The Sager says it doesn't make a difference. The doctor heard positive bowel sounds and that's all that matters.
Well, our expert disagrees with that, stating that if he had inquired and found out that there had been no bowel movement since the admission on September 5, 6 days prior to his own examination, and if he found out that the nurses had indicated that there were
own findings of abnormal bowel and tympanic sounds, meaning the presence of air, that the standard of care required him to perform a rectal examination and follow up and take steps necessary to find out, why for 6 days, this poor man had been, constipated, had no bowel movements. And I note our doctor also stated that, Dr. Shaheed deviated from the standard of care in not, considering the history of the administration of opioids to Mr. Werfel.
And why is that important?
Well, they are a constipating risk factor, along with his immobility and along with the neurological damage that he sustained on the 9th. So all those together certainly indicated that this gentleman, who was, at all times just eating a regular diet, was at risk, of severe problems, which ultimately developed because he, had not moved his bowels for an unknown time since, at least since his admission, so possibly on the 4th. And, therefore, if, considering all those factors, the Dr. Shaheed deviated from the standard of care just in not being aware of all that, in assuming
So
that
you're saying that you have shown that there is an issue of fact here, and so this should not.
that is our position. I submit that the trial court, properly, analyzed this case and found that there was indeed, a battle of the experts.
Thank you.
Thank you.
Very good. Ms. Oletta? Right. Good morning. It is still morning.
Okay. Dr. Connery was the anesthesiologist for the first surgery, the knee surgery. And the surgery went well. The patient was transferred to the special post-anesthesia unit where he's monitored for things like mobility and sensation and other things. He had no complaints. He was awake, no mobility issues. He was tested specifically and could move all his arms and legs, and he was tested for sensation. He was there about 2 hours. Dr. Connery, during that time, his shift ends, he goes home. Dr. Tobias takes over. Later on, Dr. Tobias okays the patient to be sent back up to the 7th floor. Mr. Werfel had been in the hospital since the 5th. This was the 9th. So he had been on the floor. So now he goes back to the floor. And it's at that time he's being transferred to the bed on the floor. He can't move. Okay. So the plaintiff's claim against my client is, well, you mishandled Mr. Werfel.
Well, it's not just his claim. I mean, we have the subsequent operating doctor saying that there was a traumatic event that happened interoperatively. So we have that too.
Well, it's Dr. Black who says there was a C5-6 fracture intraoperatively. Now, Dr. Black is not the surgeon. Dr. Black has no personal knowledge. Dr. Black, when he says, I'm looking at page 429 of the record, he says C5-6 fracture. There was no fracture. There were many radiology reports, no evidence of fracture. Nobody says fracture. And then Dr. Black says, see the operative report for for more details. The operative report doesn't say there was a fracture. It doesn't give any details. This is completely inaccurate. It doesn't raise a question. It's inaccurate. If Dr. Black had said a fracture occurred during his hip surgery on the 9th, he'd say he didn't have a hip surgery, he had a knee surgery. Dr. Black is wrong. This does not raise a question of fact. Plus, the plaintiff's own expert doesn't say it happened intraoperatively. This is not someone saying, I can say to a reasonable degree of certainty he had a fracture and it happened intraoperatively. He's dashing off a note.
But do we need to focus on whether or not there was a fracture with the CT scan that
No.
showed spinal cord compression?
He didn't have a fracture. He had spinal cord compression.
Right. So the point is, why are we even focusing on the fracture?
I don't want to.
All right.
I'm sorry.
That's not.
So let's talk about spinal cord compression then.
Oh, yes.
So we have this testimony at the deposition about mishandling and there being no other explanation. And then we have the errata sheet. And we have case law that says that when you have deposition testimony and an errata sheet that directly contradicts, that creates an issue of fact.
That's the law, but that's not what happened here. There is no direct conflict. Saying at his, the plaintiffs try to misquote it. What the deposition testimony is, are you aware of any other explanation for the cord compression other than mishandling? No, he says.
His mishandling.
No, that's not what he was asked. And
But he's in charge of it.
wait now, he's in charge of some, I'm sorry, I didn't mean that disrespectfully, but he's in charge of some of the transfers. He goes home. The transfer from PACU to the bed to take him up, and the transfer from the bed to the 7th floor where they say he can't move now, Dr. Courtroom was gone. So sure, Dr. Courtroom says, I can't think of anything of mishandling. He doesn't mean himself. He's probably thinking of the 7th floor when the man was found to be unable to move. When he was discharged from the PACU where he was mobile, 5 minutes before he was discharged by Dr. Tobias, he had a sensation test and he passed. Dr. Tobias, are we saying he wouldn't have noticed that the man was paralyzed when he okayed him to go up to the floor? So Dr. Conneru saying, I can't think of anything other than mishandling is not, I guess I mishandled him.
How should we consider the evidence about the blood pressure fall?
The plaintiff in his responding papers seems to abandon that incident. And even if he doesn't, the plaintiff's own expert doesn't make a connection. He says, oh, hypotension can be a result of cord compression. He doesn't say it's a big result, it's the main result, or it resulted in this case from cord compression. Our doctor listed 4 or 5 other possible reasons for the hypotension. None of them had to do with cord compression that their expert didn't mention. So there's many reasons for hypotension, and they seem to drop that argument anyway in their response. What we have is a transfer where the man can't move that had nothing to do with Dr. Coneru. So to say, oh, he admitted he was negligent because he said mishandling, I can't think of anything else. He sticks by that. I stick by it. It was mishandling, if it was any mishandling, on the 7th floor.
Wasn't it Dr. Lewis that said traumatic injury interoperatively?
I don't know.
And Dr. Lewis is the doctor who did the subsequent surgery?
He did the subsequent surgery. He didn't do the knee surgery.
No, he did the subsequent back surgery. Or
Whatever.
neck surgery.
Decompression surgery.
Right.
I don't know if he said that intraoperative. I know Dr. Black said it.
Okay.
But again, Dr. Lewis is reciting a history. He wasn't there. He wasn't there. He's reciting a history. It doesn't matter why he had cord compression to Dr. Lewis. He has a man with a cord compression. He's got to fix it. Just like when other doctors compress, like the rapid response doctor, Dr. Hobbs, was in the OR, came back, couldn't move, rapid response called. He's not saying the man never went to PACU. He's just condensing the history. They're not, those people who are writing those notes aren't saying, okay, I'm faced with when did this happen, exactly how and who did what. No, Dr. Lewis wants to cure this guy because he has a cord compression.
All right, I think we have your argument.
Okay, well, but I want to point out some other things about the plaintiff's expert opinion. Everybody knows you can't ignore inconvenient facts. According to the plaintiff's expert's entire affidavit, it's as though the 7th floor transfer never occurred. He doesn't even mention it as a possibility. He says, oh, basically, I don't know when it happened. Maybe during intubation, maybe during the transfer from the table to the cart. He ignores the other 2 transfers when Dr. Conner wasn't there. Also, he ignores all the tests that were done in the PACU, all the monitoring that was done that showed he was mobile. Doesn't say a word about those. Also, an expert giving an opinion has to have some facts to back it up. He has no facts. Maybe it happened during intubation. The intubation was smooth. It happened on the first try. The man had no teeth. He had dentures, so it makes it even smoother. And that's recorded right in the anesthesia record. It wasn't just Dr. Conner saying, oh, I think it went smoothly. It's right in the record. So why the expert comes up with, maybe it was during the intubation, there's no facts to back it up. Maybe it was during the OR to the cart transfer. Well, there are several transfers. Why does the expert pick on this one? He doesn't say. He doesn't say he was jolted, they dropped him, there was a sudden hyperflexion, whatever. Nothing. There's no
questions,
facts.
Mr. Collins, about that for sure.
I hope. And the seventh floor. So the expert then says, well, Dr. Conner admitted it, which I think we just covered. He did not admit it. And so I think the plaintiff in his brief realized he didn't admit it. So I'll say instead that the expert was giving and characterizing the import of what the doctor was saying. The import of what my doctor was saying is, I didn't do anything wrong. I was very, very careful.
But counsel, just in response to that question about the no other explanation about the mishandling.
Right.
Your client didn't say mishandling on the seventh floor.
He wasn't
mishandling
asked.
on the way to the seventh floor. Correct, but he didn't clarify. So either he misunderstood the question or we're misunderstanding the answer. But one of those has to be true for you to win here on summary judgment, right?
I'm sorry, I'm not quite understanding. I'm taking the testimony and the answer at face value. He said, asked a very specific question. Do you have another explanation? Other than the mishandling? No. Maybe he was anticipating the attorney to say, well, when did it take place, or explain, or when do you think it happened, or how do you think it happened?
All right, so it's your position that the context of the deposition doesn't reflect that it was while he was in charge of the care.
Exactly. It was the very last series of questions at the very end. I don't think it followed anything. And it said, well, you have another explanation. No. All what my client knows about the seventh floor transfer, my client knows he went home. My client knows there was a whole period of time that he wasn't involved. My client knows that during the PACU time,
I
the man was
think you
mobile.
made that really clear.
Okay.
Just last though, if then everything's fine with the deposition testimony, then why do you change the answer on the errata sheet?
Because it doesn't really change it. The difference between I don't have another explanation and I don't know. I do not know. I didn't do it. Honestly, it's a distinction without a difference. He's not saying, never mind what I said. Here's what I'm saying now. So that's not the typical, oh, first you say this and now you want to say that. So it doesn't raise a credibility issue. So
I can assure you, we will scour the expert reports to determine whether or not it was a question of fact was raised by the plaintiff.
but more than that, if I'm saying, here's not just me, I mean, it's the clear, most likely suspect is the seventh floor transfer because that's when he was rigid or immobile, and they don't even mention it, then that expert opinion has no probative value. The plaintiff somewhere in the brief wants to address that too, because his expert didn't do it. Maybe feels I got to say something. So he said, well, maybe you can have paralysis and the cord compression took place before that. That's for a doctor to say. You have cord compression, I would think, if it's going to affect your mobility, you'll do it right then. I'm not a doctor either. But you can't just throw that in your brief as an argument. And their expert says nothing about it. Nothing about the mobility test, nothing about the seventh floor. Literally misquotes the doctor. Doesn't say, well, I think he might have meant this. He misquotes it. And that's wrong.
Thank you, Ms. Owen.
Morning again, Your Honors. Supreme Court properly denied Dr. Connery's motion for summary judgment, but the court did, however, err, I submit, in holding that Dr. Connery had established his prima facie entitlement to summary judgment. As is, often the case, Dr. Conneru, as defendant, submitted an affirmation, or rather affidavit, on his own behalf, not only dealing with the facts, but rendering an expert opinion. And I submit that if a non-party independent expert had submitted an affidavit paralleling that submitted by Dr. Conneru, this court would hold that the defendant just failed to establish his prima facie entitlement to summary judgment. In his affidavit, Dr. Conneru stated that he reviewed his anesthesia records. Those are 2 pages long. Perhaps he reviewed also the 6 pages of the post-anesthesia care unit records. But again, that's only, 8 pages. Attached to his attorney's affidavit were, hundreds of pages, which the court is aware of. And, any expert could not, read only 8 pages out of hundreds of pages and render an opinion as to standard of care or approximate causation. Furthermore, Dr. Conneru did not submit his own deposition transcript, and any expert I submit who was independent, a non-party, would have to read and address, all of the deposition in this case. Simply by ignoring it, stating, hey, everything I did was okay, Dr. Conneru, I submit, failed to establish his prima facie entitlement to summary judgment.
But supposing that he did, how does your response to that raise a question of fact?
Yes. Even assuming that he did meet his threshold, plaintiff raised the triable issues of fact by pointing to the medical records that Dr. Conneru himself ignored and submitting the affirmation of an expert anesthesiologist. As to those records, at page 257 of the record, Dr. Babu, who was called in for a neurological consult, stated the patient went for a left knee arthroscopy today under general anesthesia. When the patient woke up, he was complaining of pains in his neck and he was having difficulty moving his arms and legs. So Dr. Babu, who consulted, met with the client, spoke presumably to the other care providers, stated in the hospital record that there were problems immediately upon him coming to.
Dr. Babu says that the signs of the injury to plaintiff were present still in the PACU?
Well, he didn't mention the PACU, but he said when he woke up, he was unable to move his arms and legs, or at least was having difficulty. And that upon examination, he had the contusion compression of the spinal cord at the C5, C6 level.
And when Ms. Aletta says mobile, he wasn't walking around, right? He was still in bed.
He was in bed. He never got out of bed. He might have been transferred from bed to bed. But the critical thing, I think, is that, the neurologist said when he woke up, he was experiencing these problems. Similarly, at page 379 of the record, Dr. Hobbs stated that, at approximately 5:15, patient arrived back from OR and complained of inability to move his legs. Again, that links it not to this subsequent move hours later from, the path
Somewhat of
onto
an
the floor.
alternative timeline than what we were given by the defendant.
Yes, I mean, this timeline at least raises a question of fact as to when did this manifest itself? And if it manifested itself immediately after the surgery, then clearly all signs point to the problem lying with, Dr. Conneru's mishandling of either the transfer that he was in charge of pre-surgery and post-surgery, and the intubation that he was in charge of, and in fact, personally completed during the course, of the surgery or immediately prior to the surgery.
Thank you so much. Do you have anything further?
Yes, as to Dr. Black stating he was the attending physician throughout the hospitalization. And he did state patient suffered a C5, C6 fracture intraoperatively. Even assuming that he was wrong as to the existence of a fracture, he was clearly referencing the neurological problem that resulted in the, quadriplegia. And he stated, that it occurred intraoperatively. And although Dr. Conneru argues that Dr. Black really knew nothing about this case, I mean, he was the attending physician. He was certainly authorized to and perhaps obligated to, render progress notes throughout the stay. And, again, that, combined with the other two notes I mentioned, raises a question of fact as to when this occurred. And finally, I just want to point out that this is a classic case, although the trial court didn't address it, of the applicability of the doctrine of res ipsa loquitur.
Okay, did you raise that ever? I mean, that did run through my mind. We have an unconscious patient,
Yes.
et cetera, so he couldn't have either told us what happened or participated in it. Well, was that discussed before Judge Seibert?
It was raised in our papers. Yeah, the papers were in front of her. In the attorney's affirmation and opposition, the applicability of the res ipsa loquitur doctrine based upon the patient's, being under anesthesia was raised, although Judge Seibert did not address it.
Okay.
And, as Your Honor alluded to, where someone is anesthetized during an operation, plaintiff need not conclusively eliminate all other potential causes, but instead he'd only establish that the greater probability of fault lies at the defendant's door. And here, given Dr. Conneru's own concessions that, yes, there's no real explanation other than intubation or movement of the patient to account for this, jury could, I think, applying that res ipsa doctrine, reasonably conclude that, yes, he was the one who was responsible for this, and it didn't occur hours later when he was, being transferred from one bed to another.
Okay, I think we have your argument. Thank you. Case number 85 is going to be next. W.T. Stanley Holdings Corp. versus Piazza Carpet LLC. Okay, when you're ready, counsel.
Good morning, Your Honors. Kyle Dedell and Rob Falsgraf on behalf of the appellant, W.T. Stanley Holding Corporation. It's the appellant's position on this appeal that the trial court erred in granting the respondent's motion to dismiss and summary judgment on a specific performance complaint regarding the sale of commercial property in Jamestown. As an initial matter, I'd like to point out that the trial court incorrectly stated that the record is devoid of any documentation that the commercial loan to purchase the property was ever cleared to close by the lender, or that the appellant had cash to close. But further, the order stated that the record is absent of any affidavit from the plaintiff or representative of the plaintiff, or an affidavit of an attorney for the plaintiff in the real estate transaction that disputes the defendant's claim on the motion. That's simply not true. Attached to the Bailey affidavit is a verified pleading. It's an answer in a related city court matter. That answer contains factual disputes. Disputes of all the factual allegations in the motion. It contains documentary evidence disputing the allegations. Specifically, it has 2 mortgage commitments, both of which have title issues that respondent needed to clear. It also includes a breakdown of the substantial improvements in the property, which the appellant is entitled to value in equity for the property. This pleading was signed, verified by William Stanley as president of WT Stanley Holdings. And as such, it should have been reviewed, admitted as evidence in the matter. It was clearly ignored, not considered on the motion as it should have been. Likewise, the documents include a ledger, bank statements, both of which were business records of WT Stanley. Those were submitted in opposition to the respondent's motion. They were disregarded and not reviewed on the motion. For that fact alone, I believe it's reversible error for the trial court's decision.
Isn't it your position that there were title issues that had never been cleared up, which never really allowed the sale to go forward?
That's correct, Your Honor. Kind of skipping ahead to that piece of my argument, I'll mention that there was an option to purchase the property. WT Stanley exercised that option, I believe, in June of 2022. It is not until October of 2022 that the respondent comes forward believing that they have cleared those issues. Our position is that those issues were not cleared. They're still not cleared to this day, in part because this parcel was connected to another parcel with common ownership to Piazza Carpets. As a result, they share a common water system. That is an issue that needs to be addressed. It affected not only the commitment for the lender, but clear marketable title for the sale of the property. And as such, there was a substantial delay on the respondent's side to clear that, and we believe it's still not been cleared.
With respect to the issue about the last 3 months, it seems to me that your position might be that it's just a red herring once you have an agreement that that's going to be worked into the sale price.
That's absolutely true. So under the terms of the lease, we have the ability to exercise that option at any time,
right,
whatsoever. We did properly exercise it during the time period while we were in good standing. That option was accepted. And from the record, it's abundantly clear that the respondent did acknowledge and accept that option when issued and moved it to closing. So in terms of the issues of payment, non-payment, was payment to be made at closing, all of that's been addressed. In fact, any issue regarding whether payment was made or not made ultimately was cleared up by their proposal to allow it to be made up at closing. And a true one.
And practically, this whole idea that you can exercise the option at any time, it just affects the credit. The earlier you do it, the less of a credit you receive.
That's correct. The purchase price was determined. The credit, so to speak, the $3,000 a month payment, $2,400 of which would go to the purchase price, that could be trued up at the closing. So to that point, we believe that's a non-issue. But to follow with that, the trial court erred in basing its decision on the alleged failure to make the 36 payments. There's no dispute that the option was validly exercised. There's no dispute that it was timely. What there is a dispute about is the delays, right? So June 1st, 2022, that option is exercised. It's not until October 19th, 2022 that respondent claims that they're prepared and ready to close. They're given approximately 4.5 months to clear this issue, which again, may or may not be cleared as of today. That's in sharp contrast to the 10 days that the appellant was given on the declaring time is of the essence.
Can I ask maybe a silly question? Are you still in that same location? I mean, is your business still there?
Your Honor, unfortunately, I can't speak to that because following this action, there was a city court matter to evict my client from the property. I was not the counsel on that matter, so unfortunately don't have knowledge of that.
Okay.
But they are seeking to have this order reversed, the specific performance action reinstated, and they do intend to move forward in purchasing the property.
Okay. Thank you.
Mm-hmm. Despite the best efforts to paint a picture that it was the appellant was unable to close the loan, respondent fails to address the numerous months required to deal with these title issues on the property. I've already mentioned the water access and easement issue. Again, we believe that's still not addressed. So in terms of the option, it's valid. It's been executed. We've provided the factual documentation, which was wholly disregarded by the trial court. So the only real issue, in our opinion, then, is the time is of the essence letter, right? So despite the fact that lease payments were made, approximately $86,000, despite the significant improvements in the property, which again is in the motion papers, $154,600, despite the delays caused by the respondent in clearing the title issues. My client has put approximately $240,000 towards purchasing this property, only to have it taken away with a times of the essence letter at the 11th hour. Now, I say that because it is not part of the contract. This is not something that was negotiated for. It was not bargained for. It is not something that my client agreed to. There is no times of the essence in the lease agreement, in the option contract.
Can you
Now,
even declare time is of the essence if you haven't done everything like clearing up those title issues? How can time be of the essence?
well, it's their position that they had cleared up the issues. Our position is that they had not. To answer your question, no, you cannot declare times of the essence if you still need to clear up issues.
But counsel, if it's a contract between a buyer and seller, you're saying you can't declare time is of the essence? Because it changed, the nature of the agreement changes.
That's correct. What I'm saying is it's not provided for in the contract. It does not give them the direct specific ability under the contract. Now, case law does provide them with that ability, provided they meet certain circumstances, right? Those include a clear, distinct, and unequivocal demand. I don't think we have that. And also they have to provide my client with a reasonable time to perform his obligations. And thirdly, they have to tell the other party a designated date under the contract for the closing to occur. In this particular situation, notice was served on 12/29/2022, immediately following Christmas. That time is of the essence demand was to be effective January 10th, 2023, 12 days over a Christmas holiday, over the New Year's holiday, at a time when banks are largely closed, understaffed, and unable to close loans. Law offices are largely closed, understaffed for the holiday. The clerk's office is the same situation. So you'd be in a situation where you're unable to record a deed or a mortgage, which in this case was the situation.
Well, wouldn't that be a question of fact?
I believe it would be, and I believe that was all before the trial court, but it was largely disregarded because it was submitted as part of the verified answer in lieu of the affidavit. So on that fact alone, I believe it has to go back. But beyond that, we're talking about a notice that was sent on 12 days notice through certified mail through the USPS. Now, I don't think it's a far stretch to ask the court to take judicial notice that it can take up to 5 days for a mailing to go through the USPS, given the current environment.
Mail is not what it used to be.
And I thank you for that statement. And to further complicate that, we're talking about a certified mailing, which will further delay the mailing process. So we take what is a 7 business day situation, removing the weekends, removing the holidays, adding any complicated delay for the mailing, 5 days, 6 days, maybe 7 days. And my client has no time to close this loan. It is not reasonable under the circumstances. And for that fact alone, it is not valid. And therefore, everything that follows that time is of the essence demand should not be adhered to.
Thank you, Counsel.
With that, the appellant submits for the foregoing reasons, the trial court erred in dismissing the declaratory judgment action, in declaring that the appellant is a tenant only and has only tenant rights, at admitting the hearsay evidence as to the appellant's financial condition. specifically the impressions, the speculation of the attorney that we were unable to close. That information was clearly
In the record.
provided in opposition to the motion. And we ask that the trial court order be dismissed and the declaratory judgment action be reinstated.
Thank you, counsel.
Thank you.
Thank you. If it may please the court, Joseph Calmary on behalf of the respondent, Gaza Carpet. I would first like to go into what was talked about as on the responding papers, or excuse me, the appellant's brief, which is the title issue, which in my opinion, Your Honor, is nothing more than a legal fiction. The title issues were never raised before the trial court as being any title issues. There was easements. It was spelled out right in the purchase agreement that easements are required to be provided. In the affidavit of Neil Robinson, the attorney who handled the real estate transaction for the defendant, on October 19th, 2022, he sent the proposed and agreed upon easements to the real estate counsel for the appellant. Over that time, there was never one objection to those easements. In fact, there was no objection to any of the transfer or the title work that was provided. It was not until late November, early December, where we finally found out, again, through the testimony and affidavit of Neil Robinson, the attorney for the respondent, who had the firsthand information with respect to this case at the real estate transaction, that any telephone inquiry with the real estate counsel for the appellant at that time, they didn't have sufficient resources to close. There was multiple emails. Where are we going? Is this closing? Nothing was responded to. It was non-responsive. The December 28th declaration of time of the essence letter, again, non-responsive. There was no, hey, there's
an allegation we just heard about it being unreasonable.
And Your Honor, with respect to being unreasonable, 7 business days were set forth in that letter. Mr. Huber was aware of it. There's no refuting in the trial court record that they received it, that they responded to it. They simply ignored it, and they filed this pending action before the court. Meanwhile, during this whole time of the delay and the non-responsiveness, they were there rent-free. So there was a question as to how genuine were they in anticipation of closing. The trial respondent's counsel points to commitment letters that were issued as proof that they are ready to close. A commitment letter is not a clear to close, which is exactly what the court indicated in its trial record. There's nothing from the bank saying, yes, you guys are you're in a position to close. In fact, the affidavit of Neil Robinson, again, the attorney who represented the respondent's matter, said that the reason why it was not going to close, or why the appellant was having financial difficulties closing, was because the appraisal came in lower, which doesn't happen until after the commitment letter. There's nothing in this record that shows they are in a position or able to close.
Well, did the commitment letter raise some issues about the title?
If it was, Your Honor, it would be before they even issued the title commitment or any of the receiving the proposed easements that addressed those. And I don't believe the title, it said the general provision, of course, that there would be a title reviewed by the bank to approve it. But nevertheless, all that was submitted to the appellant's attorney on October 19th. And nowhere in the record is there a response from the real estate counsel at that time that he had any objection to those documents. There's nothing in the record at the trial court level from the real estate attorney saying that he didn't receive them, he raised any objections to it. He went completely non-responsive, and they failed to pay any rent for that intervening time.
Well, this is a stretch or disingenuous to say they failed to pay rent when there's going to be a set aside on the purchase price.
Well, there was no agreement with that. We were honoring that, and we were expecting it, but the rent still wasn't there. Moreover, that would only address the rent to make up the balance of payments to get to 36 months, which terminated in September 2022. At this point, by the time the declaration time of the essence, the lease had expired on the terms, and there was an additional 2 months that had been no payment. And there had been no correspondence in the record at all. We'll make up for this, we'll settle at closing. And there was no response. They were completely non-responsive. So with that, Your Honor, we please the court, we don't know what title issue there was. It's not identified anywhere in the record. With respect to the allegations with respect to the option payment, we recognize that there was 32 of the 36 payments made. We also recognize that there was an agreement at the time the closing was to occur that those payments would be made up. It was the respondent's intention to close this property with those payments being made. So of course they were not going to nullify the option because of these failed payments. They were going to honor it. But at what point does that option go on? It does not exist.
Your client was going to insist that they make the payment and then give them the credit for that payment?
They were going to, if they were going to honor the purchase price in the lease agreement, which was $254,000, which was conditioned upon 36 timely payments, that was going to be worked out. So if they only paid 32 payments, they were going to make up the difference. So the true value of the underlying lease agreement on the option purchase was to be made at closing. But unfortunately, again, there was no communication, completely lack of response. And then there's nothing in this record that indicates otherwise. The court was not provided any information to refute the allegations, not of the attorney representing the respondent, but the respondents themselves. The respondent articulated an affidavit, the respondent's attorney articulated an affidavit setting forth the allegations, and not once were those ever responded to with any other than the self-serving and conclusory statements of appellant's counsel. And that I'll rest unless there's any further questions.
Thank you, Counsel.
Thank you.
We don't do rebuttal, sorry. Okay, case number 88, Mayfair Lane versus Noel Sutton. Mr. Kramer is going to appear virtually.
Sure.
Mr. Kramer, good morning.
Good morning. May it please the court, Eric Kramer, Colligan Law, on behalf of plaintiff appellant Mayfair Lane.
Yeah.
This matter concerns a private street in Buffalo where respondent resides. Appellant Mayfair is an abutting property owner who seeks to enforce restrictive covenants in the title record.
Counsel, just turning to your fourth cause of action.
Yes.
In the complaint, it's characterized as a breach of a deed covenant. It's not it's not a cause of action to enforce a restrictive covenant. But yet in your brief, you claim that that's what it is, but it reads a little bit differently, and it just requests damages for the breach. And your opponents argued that, well, if we just have a claim for money damages, that's not appropriate then for a notice of pendency. How do you respond to that?
Your Honor, based upon the stipulated order from Judge Watajic, which memorializes the respondent's duties to pay 1/21st of proportionate share of things like cost of maintenance, upkeep, repair of payment, infrastructure improvements. Those are all restrictive covenants that run with the land. And
no. I mean, you have a stipulated order, so I suspect that may be why you didn't feel the need to bring an action to enforce the restrictive covenant, because you already had the stipulated order. I get that. But it seems to me that the issue comes back to whether or not the notice of pendency was proper.
Yes, and here we have because it's a breach of a deed covenant, he's already breached it. The enforcement is a remedy, is the breach remedy, is that he pays his 1/21st share. That's enforcement of the deed covenant. It would be him paying his 1/21st share. The fact that it has to do that it's covered by money is not unusual for these types of abutting property owner cases. If there's a requirement that everyone keep their bushes at 6 feet high, you're gonna have to pay someone to do that or do it. There's a monetary component to it. That doesn't make it any less of a restrictive covenant that runs with the land, which we are seeking redress for breach of the restrictive covenant. To say that it has no—
Counsel, can I ask you a question? Are you claiming any right or interest and title to the property itself?
All of these properties are from an original Mayfair parcel. And
are you claiming any right or interest or in the title to the property itself? Yes or no, counsel?
We have a claim that the title to the property is affected clearly, and we have an interest in the title to the property because all the neighbors of this private street share these restrictive covenants for the benefit of the street. So yes, there is a vested interest. Mr. Sutton can't access his home without these repairs that have now been made. All the other property owners were assessed a $50,000 assessment. Mr. Sutton's situation is a little bit different because he's not part of Mayfair Lane, Inc. But that doesn't change Mayfair's rights here in terms of enforcing a deed covenant or seeking redress for a breach of the deed covenant. They have the right to recover those funds from him due to not only an order, but an order that says the basis for his 121st payment is a deed covenant that runs with the land, which is exactly the kind of situation, according to the statutes, the case commentaries, every New York practice summary I could find, and this Fourth Department case law that says that, when you have this kind of deed covenant that runs with the land, it is an appropriate situation, whether it's for money damages or not. The money damages would be required to bring Mr. Sutton into compliance with his restrictive deed covenant. So I think that titling it breach of deed covenant does not foreclose us from what the action is, which is to seek redress for Mr. Sutton's failure to comply.
But the only concern, we have the Renfro case from our court 2022. It says there has to be a direct relationship between the relief sought in the complaint and title to or possession of the property. If the relief sought in the complaint which is just the payment, if the payment's made, how does that affect title to or possession of the property? Title to or possession of the property stays exactly the same.
I understand your point. And if it's tied to, it affects the title to the property, because a good faith purchaser would be unwittingly buying this property, which almost happened in this case, buying this property without knowing that it's subject to these deed covenants that at present, it's an additional at least 50,000 plus all of the additional assessments that haven't been paid. And
wouldn't they know that? Wouldn't they know that just by reading the deed? Or you're talking about the past payments that are owed?
The past payments that are owed.
Well, why would they necessarily be responsible? Why would the new owner be responsible for those? That would seem that the former owner would be responsible if they were incurred during their ownership. Right.
But because these obligations are run with the land, upon taking possession of the premises, a good faith purchaser would be on the hook for those fees.
So couldn't they just file a lien as opposed to a notice of pendency?
Your Honor, our remedy would be to seek an action for breach because it's been memorialized in an order by Judge Wojtaszek. And as a result, we seek a breach of that or a defiance of that court order, but it's also a clear violation of the deed covenants. And as a result, the respondent shouldn't be able to escape his obligations by trying to sell the property without notice of these debts which are owed. And I use the term debt intentionally because I think that the idea that it is just about money is a red herring. The fact that the deed covenant could be complied with by spending money is not unusual. And here, Mr. Sutton's refusal to pay has left the other homeowners in a precarious position where they're forced to fund a huge project that he's told the world he's agreed to be responsible for by entering into a stipulation that was so ordered by Judge Wojtaszek.
Okay, counsel, I think we have your argument.
Thank you.
Okay, Mr. Gwitt.
Good morning.
Morning.
So we get to talk about notice of pendency, which is one of my favorite things. So listen, it's a powerful tool, right? You can file a piece of paper that ties up someone's property, which is exactly what Mayfair Lane did here. And so what the Court of Appeals has said and what this court has said in the Renfro case and the Preston case is if you're going to do that, then you have to have a cause of action that directly, if granted, directly impacts title, interest, possession of real property. And the only thing we look at is the complaint. Sorry.
But opposing counsel's last point about the fact that it runs with the land, that the expenses run with the land. This isn't a situation where your client hired a contractor and then they have a dispute as to payment And that the contractor now is going to try to file a notice of pendency to attach property that that has nothing to do with anything. This isn't that situation because the contractor's bill allegedly doesn't run with the land, but here it does because of the restricted covenant. So why wouldn't we want to put a potential purchaser on notice?
But one, the contractor's bill, and there is no contractor's bill, but there, in this case, but there is no bill that runs with the land. And Your Honor, the questions you asked were squarely on point, which is, what did you sue for? Well, I sued for money. And as the Court of Appeals said in the 5303 realty case, if you sue for money and money only, which is what they did, you forfeit your ability to file a notice of pendency. And as I think the court pointed out in its questions, you didn't sue to enforce a deed covenant. You're just claiming that there's a breach and you're entitled to money because of it. And we need to go no further than the complaint and what is in their ad damnum clause, their wherefore clause. For damages as set forth in the 4 causes of action in an amount to be determined by trial. That's it. It doesn't say for a declaration that there was a breach of a deed covenant. It doesn't say that we have a right, title, or interest in Mr. Sutton's property. It just says we want money. And by the way, the notice of pendency says the same thing, for payment of money. So they've only sued for payment of money. And what they said in 5303 Realty and in Renfro and in Preston from this court is just because you mention real property in your complaint doesn't mean you're allowed to file a notice of pendency. Just because you're seeking money, for example, it was either Renfro or Preston, I'm getting it mixed in my head, it was a trespass action. Okay, a trespass ties to real property, it mentions real property, but you've only sued for damages, for money damages on that trespass. And because of that, because you only want money, you don't get to file a notice of pendency. If this complaint were granted in its entirety, if they won on every cause of action, they would get a money judgment. And that judgment would not touch Mr. Sutton's property. It would have nothing to do with his property. So, and that's really the issue here, is they want to, the trial court properly canceled the notice of pendency. They tied up his property when the judgment they seek has nothing to do with his property.
So from your view, the restrictive covenant that's in the deed just refers to prospective expenses as part of this homeowners association. That's what you're agreeing to. That's what you read when you read the deed.
Absolutely.
That's what you accept if you're a purchaser.
Absolutely. And by the way, if Mr. Sutton owed this money, for example, and then he sold the property, their judgment would be against Mr. Sutton for the time he owned the property. And then the next person would have to pay what was incurred as they went forward.
Has there been any subsequent proceedings in this case? Meaning that this case is about the notice of pendency. Has there been any further proceedings?
So what, after the notice of pendency was canceled, we answered, there's a counterclaim for slander of title, as you would expect. We lost a sale of property. The house was going to be sold for, I think, 1.6 million, and we lost the sale because of the notice of pendency. So right now we're just in a discovery phase, but that's where we stand right now.
Okay. But so you're awaiting trial. You haven't had one.
Have not. So look, at the end of the day, I mean, this court's law, the Court of Appeals law is it couldn't be more clear. It just says if the judgment sought means to directly affect title, possession, interest. And there is no question the judgment does not do that here. I know it sounds technical, but this is technical stuff, and it should be technical stuff. And the Court of Appeals has said, you need to be hyper-technical on this because the notice of pendency is such a powerful procedural tool.
Okay, we have your argument. Thank you.
Thank you.
Okay, case number 90. KO Bar and Grill versus Midstate Mutual Insurance Company. Mr. Becker is going to appear virtually, is that right? Okay, counsel.
May it please the court, Matthew Whitty Leach of Rough Falls Draft on behalf of the defendant, Appellate, Midstate Mutual Insurance Company, appealing the order denying Midstate's motion for summary judgment dated January 22nd, 2024, from Judge Gretton. First and foremost, the trial court erred here because there is no insurable interest that KO Bar possessed. Under insurance law 3401 is an absolute prerequisite to be afforded insurance coverage that you must have an insurable interest. 3401 goes on to define an insurable interest as substantial economic interest, which case law further defines as a direct and not a merely remote or consequential effect on the property. And here there just was not an insurable interest. So first, ownership can't be the basis.
You know, this case is a little complicated in the fact that the person who owned the bar also owned the building, and there's insurance, and it seems a little fuzzy to me about, you know, what was being insured. Okay, sometimes you all treated the two entities like they were separate, and sometimes you treated the two entities like they were one. I think there was something at some point, there was reference to, oh, just write one check, okay, whatever, regarding the insurance coverage. Why aren't we looking at a question of fact here with regard to both the insurable interest and the source of the damage?
So the reason we're not is because, again, there's no ownership and there may have been some overlap between the two, but additionally, the landlord is the only one with an insurable interest here. And he chose to keep the corporate entities separate. For whatever reason, Mr. Osinski, the owner, as you mentioned, of both the single member LLCs, he chose to have an operating company and a company whole title. And we would be completely discarding corporate form, which is against, you know, public policy, I would say, but also just against, you know, corporate principles in general, if we were to just dispose of those.
Is that supposed to be viewed so narrowly? I have a case, Azado from the Second Department, 2012. Party possesses an insurable interest where he has such relation or connection with or concern in the property that he will derive pecuniary benefit or advantage or will suffer pecuniary loss from its destruction. I mean, it seems that the interest is supposed to be viewed pretty broadly.
Well, I think the difference is this is two steps. Whereas just like the case is cited to by the respondent, in those cases, it would have been if KO Bar had an interest in the holding company, but that's not the case here. They have no ownership interest in one another. They're owned by the same person, but again, they chose to have a different corporate form. And, you know, I'm sure he would take position in another case that if, you know, KO Bar was sued, they can't go after the property because it's held by a different entity. So he chose to have the corporate set up the way he did. And unfortunately for him, the result of that is the property was not insured under the correct company.
I think we have your argument.
Can I address just the wear and tear argument really
You'd
quick?
like to, sure.
Yes, so just briefly on the wear and tear argument. Their affidavit is just completely insufficient. They don't give any background or basis for the conclusions. And also it appears they agree with that was wear and tear because their affidavit states it appeared that the leader froze and broke, allowing water to leak into the interfacial space where it froze again. So multiple occurrences, which fits directly into wear and tear. And with that, I will rest unless there's any other questions.
Thank you, Kevin. Mr. Becker? We can't hear you.
Good morning. May it please the court. Thank you, Judge Bannister. Paul Becker for KO Bar and Grill. So I won't rehash everything. I think the court understands a lot of my arguments. Legal title is not necessary to have an insurable interest. One of the things I kept hearing opposing counsel say is he chose to have the corporation set up this way, that way. My client went to the insurance agent, and again, this defendant only sells insurance through their agents. You can't buy it online. You can't call them up. They drafted this contract. They sold insurance in one single policy for both the property and the business. There were questions of facts that I pointed out in my brief as to who was supposed to be properly named on it. There was an application and there was a quote. I won't go through that all exactly, but when you look, there's issues of fact as to who was supposed to be named on both of those. I think the fact that this was sold in one policy says a lot.
The wear and tear issue.
Sure, with the wear and tear, I think there's actually some things they both agree on. Both experts agree that this had to deal with frozen water. It's interesting that the policy itself and the insurance company's policy is that there be an inspection before a policy is even issued. The policy was sold in 2016. Their expert says this happened over years and years and years. So if there was extensive damage over years, why did they even insure the place? You know, the events, just the fortuitous event happened just a few years after they sold them the policy. So when it comes to the event happening, yes, I think their expert actually says, hey, there was an exacerbating event here. I mean, that alone says that there was something fortuitous that happened. He doesn't say what the state of the building was prior to that. Sure, this is like all North Buffalo buildings, 100 years old. There's going to be something, but it's interesting to note that this damage occurred exactly in between the space where the pipe had frozen and burst. Okay, the rest of the building was fine. So I think there's questions of fact as to whether or not this was pre-existing, or I should say, a fortuitous event or wear and tear. And I'd just like to point out really quickly, if I could, if you look at the case law that was pointed out, Franklin, 200 Court Street, Bodine, and United States Dredging, all those cases, those were summary judgment motions, but in those cases, there's evidence of damage prior to the fortuitous event. For example, in Franklin, 2 days before the fortuitous event, there were complaints about the condition of the building. Okay, there was large cracks reported. In 200 Court Street, there were historical photos showing damage prior to the fortuitous event, including patches to the facade of the building. In Bodine, there was other issues, including proper drainage and construction that was made, structural changes to the building before the event. And in United States Dredging, that was actually a case that went to trial. And in that case, the judge determined that plaintiff's own proof in a motion after trial actually disproved their case.
I think we have your argument. Thank you.
Okay, thank you.
Of course, that is